Yes. May I beg to item number 4. I need some little accommodation you receive in this case.
That is a compassionate appointment case.
Commissioner, you see, I supposed to bring this.
You are for the respondent.
I'm for the respondent. You see, in this matters, last question I got some instruction, and after this I supposed to file a affidavit. So I was not in a position to contact the official here in Shillong.
Petitioner?
Petitioner, Ja, I didn't see him.
Wait for him. Let him just make a mention at the time when it's come. Yes.
My lord, I beg to mention item number 3. My lord, we are supposed to get the copy of the award statement. My lord, we have got instruction that it has been able to be located, but I need some more time to get the printed copy, and I am praying for 2 weeks time, my lord.
Your Lordship.
Yes, Mr. S. Sanganta, Learned State Council. 6. Grant of further time for producing
Award statement.
the copy of the award statement. Or
Yes, copy of the award statement.
copy of the award statement. The prayer has not been opposed by the London Council with the petitioner. Accordingly, prayer allowed, list after 2 weeks.
Highly obliged.
Obliged, Your Lordship.
May please, Lordship, I beg to make a mention on party of the hearing list, item number 9, Your Lordship. The conducting counsel, senior counsel is in this post. So this matter may be fixed after 3 weeks.
Item number 9.
9 years, Your Lordship. I have informed the other side.
Your Lordship, if this matter may come out after 2 weeks instead of 3 weeks, Your Lordship.
Yes, on the request made on behalf of the respondent, list this matter after 2 weeks.
And I have a similar prayer with regard to item number 11 and 13. 11 and 13.
11, you are making mention on behalf
On
of
behalf of this Ravi Gurung, yes, I'm for the state.
state respondent.
Yes, Lordship. Yes, I'm
For the
present.
petitioner.
We are for the petitioner. Item number 13, sir.
You have no objection.
I'm for the no objection.
Okay, 11 also 2 weeks on the request made on my behalf. Request made by Mr. H. Abram on behalf of the state respondents.
11.
And then 11 and
13.
13.
13. 13 also state respondent.
Yes, Your Lordship.
We are for the petitioner, Your
You
Lordship.
have no objection.
I'm on behalf of respondent number 3. I'm on behalf of respondent number 3.
In 13.
Lordship, I'm only in 11.
Okay, just record the name. None of you have objection, isn't it?
No, Your Lordship.
Just say same order on the request made on the list after 2 weeks.
2 weeks, yes.
Yes.
Hello,
Obliged,
Lordship.
Your Lordship.
Your Lordship, item number 14.
Criminal appeal.
Yes.
Item number 14, Your Lordship. Machinery is out of station, Your Lordship. In matter of that Shillong Localist National Moot Court competition.
You are appearing on behalf of the making mention on behalf of the
Appellant.
Appellant, Your Lordship. Yes.
you want time.
Your Lordship, after 1 week, Your Lordship.
No objection, my lord.
Okay, on the request made on behalf of the appellant, list this matter after 2 weeks. Yes.
Obliged.
Bless Your Lordship.
May I please, Your Lordship? I beg to mention item number 2, Your Lordship. Number 2.
Item number
2.
item number 2. The first item of the hearing.
Yes, Your Lordship.
Yes. What happened?
The senior counsel is not keeping well, Your Lordship. Yeah, I read it. The senior counsel is not keeping well.
Who
Your
is senior counsel?
Lordship. A.H. Hasarka.
He is not well.
Yes, Your Lordship.
So
1 week time, Your Lordship.
yes,
No objection, Lordship.
you'll be all right in 1 week.
Yes, Your Lordship.
Yes. Just say list after 1 week on the request made on behalf of the petitioner. Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 5. My learned counsel is facing personal difficulties. Kindly let this matter come after 2 weeks.
This is a matter, madam, it should have been finished. It was hard quite number of times, isn't it?
Yes, my lord. Regarding the passport, my lord.
What is the difficulty today?
Senior
It's
counsel.
personal, pardon?
Is the personal difficulty?
Yes, Lordship.
Yes, a request has been made to adjourn the matter by 2 weeks on the ground that the counsel for the petitioner, appearing for the petitioner has some personal difficulty. The state has no objection. At least after 2 weeks.
Obliged, my lord.
Yes.
Lordship, I beg to mention item number 8. The conducting counsel is on sanction leave, Your Lordship.
Who is the conducting counsel?
S. Pandit, Your Lordship.
Is on sanction leave?
Yes, Your Lordship.
Lordship, I'm appearing on behalf of respondent number 1, Your Lordship.
Any objection?
No objection, Your Lordship.
When do you want?
After 2 weeks, Lordship.
Wait. After 2 weeks on the request made on the petition. Yes.
Much Lordship.
Yes. Yes, madam. Anything? Somebody is there online.
Yes, Lordship.
Yes.
May I please, your Lordship? Lordship, I beg to mention item number 6 of today's list, Lordship. I have taken consent from the other side, Lordship. Matter may be passed over for today. Conducting counsel PP Thakur is not available today.
Yes.
Yes,
Lordship.
Lordship, I've been contacted this year.
Matter may be
When do you want it? After a week?
after 3 weeks, Lordship.
Lordship.
They have filed the affidavit. We have received the copy.
Why 3 weeks? Anyway, just on the request made on behalf of the petitioner.
Lordship, we need some instructions, Lordship.
It's okay. On the request made on behalf of the petitioner and not been objected by the learned counsel for the state, list this matter after 3 weeks.
Much obliged.
Lordship, obliged.
Yes.
Supplementary cost list, item number 1.
Yes, Mr. Khan. Oh, there was a mistake. Was
Lordship.
it corrected?
Lordship, yes. And we are grateful, Your Lordship. In fact, it was not something of light thing, it was very important part.
Okay, we do not know whether it was important for me.
It was,
But then you wanted to proceed with it.
yeah, I know. We're grateful to Your
Yes,
Lordship.
where were we?
Page 36, Your Lordship. I was reading page 36. When we have 3 POXO matters fixed for hearing in the morning, and also this motion, so I tend to overlook.
It's all right. If you have difficulty, we can pass
No,
it
no,
over.
no, no,
If
no,
you-
today, no. No, it's a very urgent matter, so. And it's always a pleasure to appear before this court. So, Lordship 36, Lordship will recollect 6. Nature of offence and section of law. Position of 2 white crown hornbill. So,
And then 13. We were on para 13.
and then we were in para 13.
Yes.
Lordship, should I read the para 13 again? It's a very small paragraph.
Where we
We finished the first 2 paragraphs. We stop in the last part with
he
the.
speaks about the seizure of the
Yes.
birds and all.
So,
is it?
Lordship, I'll just come to the last part, then we'll come to page 36A.
Yes.
The second accused, the accused were seized with the possession of 7 individuals of bird, out of which 6 hornbill species and 1 red so-and-so, 1 black color wallet, 1 Redmi 9A touch screen mobile, light blue in color, and 1 Redmi RX 320 touch screens, and with a Toyota Fortuner vehicle AS01A Z 0011 due to violation of section 911 so-and-so of the Wildlife Protection Act. Both the detained accused has been arrested on 3/9/2023 at about 6:30 p.m. by Umari Police Station and registered the case at Forest Range Officer through so-and-so. Lordship, what is relevant in this seizure is the seizure of the bird and also, Your Lordship, the conveying vehicle, that means Toyota Fortuner vehicle so-and-so. My main thrust of the case is this two only. And why it is relevant? Lordship, I'll just give you, Lordship, the Act of 1972. Wildlife Protection Act 1972. Section 39.
You have given me 2 books.
Let the copy. Section 39.
Yes.
Lordship, trade or commerce in wildlife, animals, articles, and trophies. Lordship has got it.
Yes.
39A, wild animals, etc., to be government property. 1. Every. Lordship, from every, Your Lordship, I'll come straight to D. Because A, B, C is not relevant for the purpose.
Okay. Yes.
Every, D, Lordship has got it.
Yes.
Every vehicle. Vessel, we are not concerned with vehicle, Your Lordship, we are concerned with vehicle. Vessel, weapon, trap, or tool that has been used for committing an offence and has been seized under the provision of the Act shall be the property of state government, and whereas animal is hunted in the sanctuary of so and so. Your Lordship, the second part we are not concerned. The relevant part is the vehicle seized in committing such offence shall be the property of state government.
That means moment it is seized, it becomes terrorist. Whether it is seized genuinely, just only on the basis.
Lordship is correct. What is following from? I know what is coming.
When it becomes the government.
No, Lordship. Lordship, first of all, there has to be an offence. We'll come to it. Lordship, to answer that query.
Is it not? It would be after establishment of the offence.
Lordship is correct. Lordship, I'll answer that query. I'll answer that query. So what this particular, it's a very strange provision, Lordship, to be very candid and frank. I also have come across this particular case for the first time. So I'm just trying to assess the court. So the Act clearly says this vehicle shall belong, and what is fallen from your Lordship will answer subsequently, shall belong to the state government. Now in this case, your Lordship, now if you come back, now your Lordship, if I take your Lordship to the birds seized, and whether the issue is this, whether these birds, Lordship will ask me a question whether these birds are in the list on in the Act. First, we have to overcome that hurdle because both the courts have gone into a wrong tangent.
But then right now we are concerned with seizure.
Lordship, yes. Lordship, yes.
Now, rightly or wrongly, a case has been registered.
Lordship,
isn't it?
Lordship,
and it's being investigated.
Lordship.
Now, during the course of the case, certain seizures were made.
Lordship.
And it appears that consequent upon filing of an application for Jimma, the courts, rather the trial court has released it, which was affirmed by
the High Court. Yes, by the appellate court.
So that is way.
That is the way.
See, like you are standing against concurrent findings, so you will have more difficulty in
on facts. On Lordship is very correct because I am relying on the 39.
Until unless something very.
Yes, Lordship, I am coming. Lordship, will just take your Lordship the first page of my petition, page 109.
Your petition.
180, page 180. Sorry, I'll stick to 180. No, 180, 109, 109. Lordship has got 180.
Yes.
Lordship will come to serial number 109, left.
Page 180, serial number 109.
109.
Yes.
Lordship, immediately before 108, the word used is hornbills.
Yes, hornbills.
And 109, this is the scientific name of hornbill, which is otherwise known as Oneirinus species. So this is the white colored.
Oneirinus. Yes. Okay. These are the varieties. Okay.
These are the white species. 111 is again another variety.
Yes.
Why this is important, Lordship? When I read the impugn order, Lordship will appreciate my argument. Why this is important? So it is in the list of the Wildlife Act. And then unprotected animals. And the second is And your lordship will come to 166, page 166. Lorry, the other bird which was seized, 329. Lordship has got it, page 166.
Your pagination or such, you write 164
I
as
know.
169. Now that is what the problem is.
I apologize, Lordship.
Maybe you're in too much hurry and then. One 66 is written like 160. 164 is written like 169.
That
Now-
pagination.
Anyway, yes.
Apologies, Lordship has got it 329.
329. Yours history.
EOS historical, and your lordship will immediately be above 329 is Loris.
Yes.
So the seized bird that I read out in the Caesar are all protected birds.
Yes. Right now we will go by that only.
Now,
Since
now,
it is
now,
being caught, yes.
no, that the both the courts have disagreed. They says no, these are not native of India. They are on their ground they release. That is where the issue is. I'll come to it, Lordship. Lordship will now come to the impugn order.
Yes. Which one? Both the orders are impugned.
Lordship will District Judge, Lordship, page 23. Relevant part starts from page 24, Lordship.
Yes.
So, Lordship,
This is a criminal appeal.
Lordship, again,
Under what section?
no, this was again under 382 of the CRPC.
What is 382 CRPC says? Just see. It speaks about format of an appeal. It has nothing to do with appeal. Nothing to do with authorization of appeal or doesn't create an appeal.
Lordship is absolutely correct.
How the order passed?
No.
In a Zimma application becomes appealable.
Lordship,
Until unless that is being made of the final order. There are two different aspects. See, 451 or 452 and 457.
Lordship,
Now
yes.
this order is passed under 457. How this appeal be filed?
No, this is the appellate court's order.
No, but then how appeal became maintained? How this appeal was entered? See 482. Just
Yes,
see.
Lordship is
Open
correct.
482.
Lordship is
Just read
correct. Lordship is correct.
it. Oh, 382, not
382. Petition of appeal.
See, it should say what should appeal should contain. Nothing else.
No, Lordship is correct.
So if appeal is not created by statute, can you file an appeal?
No.
Then
Absolutely, Lordship is correct. No, we had a situation, Lordship. I was aware that these things are going to fall from the court. I was aware of it.
but you are standing here, you have to clarify all those things.
No, Lordship is correct.
This court has clarified it on many occasions, Mr.
Lordship, just be lenient on me on that part of it, procedure part of it, because we're dealing with very different type of situations in the trial court.
No, we'll ask for, you see, the legality of each and every stage of the
Yes, Lordship is correct. But Lordship, that apart, that can come subsequently. Lordship, can you just allow me to finish the argument that I'm forwarding?
If your appeal was not maintainable, then this 482 application also will not. Just because the appeal has been entertained would not confer a jurisdiction on this.
Your Lordship is correct. That is absolutely settled law. If we didn't have a jurisdiction, then subsequently nothing will happen.
Anyway, yes, where you?
No, Your Lordship, kindly allow me to just read the order.
Yes.
It's a short order, so page 24.
Yes.
The criminal appeal has been preferred by the appellant under so-and-so and the impugn order 39/2023 passed by court of so-and-so in complaint number so-and-so under section so-and-so of the Wildlife Protection Act, wherein the court of learned GMFC Nongpo has granted Zimma custody to the vehicle Toyota Fortuner bearing registration so-and-so to the respondent, which was seized in the incident appeal on 3/9/2023. The relevant facts for consideration in the appeal is that on 3/9/2023, the appellant received a call from Divisional Forage Officer, Khasi Hills Wildlife Division, Shillong, that the police of so-and-so has apprehended two persons, namely so-and-so and so-and-so of Assam, with the possession of wildlife. It was very late at night. A request was made by the appellant to the officer in charge of Kanapada PSC, Umbrai, to detain the accused person, wildlife, and the vehicle at the PSC. On the following date, that is 4/9/2020, the appellant along with the staff went and brought the accused persons along with the wildlife loaded in the opposite vehicle. The appellant found that the possession of accused persons were 7 individuals' birds, out of which 6 hornbills, 4 were alive and 2 dead, and 1 red and blue lorry. The appellant had seized from the possession of the accused person the above mentioned wildlife and also a sum of rupees so and so, 1 black color leather so and so, 1 Realme RMV 323 touchscreen mobile grey in color, and Toyota Fortuner bearing registration number, and they registered a case against accused persons for violation of Wildlife Protection Act 1972. Thereafter, the accused person so and so and so and so was produced before the court of London JMFC and released on execution of personal bond. The accused person in the instant case was authorized person of the one Sri Pranad De, who had executed an affidavit duly notarized by Kamrup Guwahati, Government of Assam, to take care of a 4-sheet Fortuner bearing registration number so and so for all purpose, that is personal or commercial purpose, for the one period. Now this is relevant in Lordship, para 4. That after the seizure of the vehicle on 3 and so, the respondent filed an application under 457 CRPC for Zimma custody of the said vehicle used in commission of offence. And the application for release of the said vehicle was vehemently objected, as he is not the registered owner of the vehicle. The learned trial court had called for report, and it was found that the said vehicle does not belong to respondent but belong to Sri Pranad De, which was used by the accused person on 12/1/2023. It is stated in the appeal that as per section 39 of the Wildlife Act, the seizure like vehicle, vessels, weapon, trap boat, tool, etc. shall be the property of state government, and without going through the impugn order, dated so and so, given Zimma custody of the said vehicle to respondent. For the sake of convenience, the impugn order dated so and so is quoted below. So Lordship, I'll skip this part because the same thing has been argued. The relevant part, if we come back, is being aggrieved, para 6. Para 6 is again the ground, so I'll skip this part because this was the ground against the. The relevant page would be page 29, para 8.
Yes.
So para 8, Lordship, again the reasoning starts from para 8. Learned counsel for the appellant further submits that since the vehicle was seized from the position of accused, now this is very important, Lordship, and not from the respondent, the question of handing over the vehicle to respondent is highly illegal. Further, under the section so and so of the Wildlife Protection Act 1972, that the grant of Zimma is not applicable on vehicle, vessels, weapons, trap or tools that has been used for committing an offence and has been seized under section 39 of the Act. The said seizure shall be the property of state government, and in case there is an animal hunted in sanctuary of so and so and so and so declared by central government, such animals or articles, trophy, etc. shall be the property of central government.
Now, are you maintaining the same contention before this court? The question comes back to same things. And if this is the what, if this proposition
Lordship.
of law is to be accepted,
Lordship.
then anyone who is caught
Lordship.
and booked under wildlife, his vehicle will be seized and the government will say, I am the owner.
That, unfortunately, Lordship, that's the law.
Cannot be.
Lordship, Lordship, I'll rely on a similar situation that happened. I'll rely on a judgment. But the argument was built in a different line. I'll come to it.
If I am falsely caught while I am going somewhere with my vehicle, and I am caught and it has been alleged that I was carrying some animals and all, and I've been booked under this thing, my vehicle will become the property of the government.
Lordship, there has to be a distinction. In this instant case, they have not denied that they have been falsely caught.
Who will determine the correctness of an allegation at the stage?
If you dispute it, then Lordship is correct. But if you admit, yes, I was carrying this all these wildlife animals in a vehicle.
See, the carrying itself will not make the act illegal. We have to see whether this carrying was illegal or not. That has to be determined. Then why do you have the procedure of having investigation and the trial then?
Lordship is correct. Lordship is correct. Lordship is correct.
These things are not going together. It cannot.
No, we're not illegal. Lordship, will just come to para 12.
Yes.
The learned counsel for the respondent further submits that the birds seized from the possession of the accused persons were exotic species, and the same does not come within the purview or under the schedule of so and so. So they were denying that it comes within the Act, and the reasoning is that the Department, Ministry of Environment, Forests and Climate Change, Government of India has already submitted a report to IU.
So who determines that whether this seized birds falls under the exotic category or not, exotic species or not?
Lordship, I read out the schedule. That's why
No, that is okay, but then who will determine it?
no,
That is
under
there in law.
prima facie under the Act, these are the birds which come within the
At
Act.
what stage it will be determined?
Lordship, yes. I'll come to it. Lordship will come to it. I precisely will answer that question when I rely on a judgment.
You have to be mindful of one thing, that we are in 482.
Yes, Lordship, yes. Lordship will kindly see, let me just conclude paragraph 12. That the Department, Ministry of Environment, Forest and Climate Change, Government of India has already submitted a report to IO regarding identification of the species in connection with the case, whereby it is clear that the sea species are exotic species and not native to India. No, I'll come to the letter, Your Lordship. They have not quoted Wildlife Act, it has nothing to do with native. And their argument is this, Lordship, very interesting in this case. The argument is this: if it doesn't come as a native bird, then the Act is not applicable. The question of Caesar does not apply. Had that been the case, even if it's under the Act, still I should be released on Zimma, then it's a different argument altogether. They admit in being in possession of wildlife, but only this thing is that the Acts are not applicable to us because of so and so. And I'll come to that letter. Our main thrust is this: whether that letter will be applicable or the Act. Because the entire case is not the Act. If the Act is applicable, then the law will follow. But they say the Act is not applicable.
Generally, offences under the Wildlife Act.
Yes, yes. But this...
What is the procedure applied in kinds of offences of trial under the Wildlife Act?
Lordship, it's
We
another
follow
one.
CRPC.
Lordship, yes. The
CRPC
procedure.
is applicable.
Lordship, yes.
So if CRPC applies, the provisions of JIMMA also will apply.
Lordship is correct. But
Now,
here,
on what basis you say JIMMA is barred? Just
no,
because...
we're not saying Zimma is bad. Lordship, I'll come to it. Lordship, allow me to just finish this argument. Because the trend, the argument that the court reasoned was that because of this letter from climate change, and this is not native. So the whole argument is the Act itself is not applicable, they're relying on climate change. Now, if the court comes to the conclusion the Act is applicable, then everything falls in place. The only issue then the court will have to decide is whether Zimma will be applicable or not.
No, even if court comes to find that Act is not applicable, then what happens? Then there will be no right to release on JIMMA.
Then the Lordship, if the Act is not applicable, then the right to Zimma will automatically follow.
See, what happens finally, that is a different issue.
Yes.
These are all prima facie observations.
Lordship.
So, per se, there is no illegality.
Lordship, allow me to just see para 4, the operative part. Para 14 of the judgment.
Yes. This court is not stopping you from...
No. I'm also learning in this case, Lordship. We're on the same page. I have heard both counsels and for the parties and peruse the record received from so-and-so. This court finds that learned CMGS had not committed any error in passing the MP order dated 39/2023. The respondent became the owner of the seized vehicle after his purchase, the same from so-and-so, white agreement so-and-so and delivery challenge, and those birds were seized from the possession of accused persons and not from the possession of respondent. So it's an admitted fact that possession from accused is not denied before the court. The contention raised by the appellant in the appeal is that once the said vehicle has been, again the same argument, Your Lordship. Now what is the finding of this court, Your Lordship? This is from the middle. This court does not agree with the contention of appellant that any seized like vehicle, vessels, weapon, etc. shall be the property of state government as per section 39 of Wildlife Protection Act 1972.
That is at that stage.
No, had it stayed at this stage, but the court totally subjectively say, I don't agree with the law. This is basically it means.
This is not the meaning, you see, like, anyway, that is your submission, okay.
Had it said at this stage of investigation, yes, but it says, no, I don't agree with
While
it.
reading, you can add it.
Yes. The court says, no, I don't agree with this contention. This law is bad law. So what if it belongs to government? But this is a bad law. Can the court do that? That's a different issue. In the present case, the recovered birds were exotic species and not, this is important, and not native to India. Therefore, they do not come under the purview under the schedule of Wildlife Act 1972. As identified by Department and Ministry of Forests, Climate Change, Government of India in his letter 5/9/2023. The case record reveals that so and so. So, Lordship, the rest part of it is that.
So there is a letter dated 5/9/2023. What does it say?
Lordship, yes.
Anyway, then complete your thing. Complete it.
Lordship, yes.
Just see it.
Okay, what page? 5. Lordship, that is a page 37.
So far as this order is your reading is complete.
Yes, the order is complete. So that means the finding is that I don't agree the Act is not applicable and possession is not denied. But why it is not applicable? Why should we both the
You are arguing something like, you see, like in a final. I don't think like in Jimma application we do not.
I'll conclude my argument on the basis of judgment. On the basis of judgment.
Yes.
Because this is a very peculiar law. Then Lordship will just come to page 37.
What is the date of the order?
12th. (15, 12, 23, Lordship. Page 23.
15 or 23. You are coming after quite some time. This is December order last year. It's already 4 months gone. No limitation applies. Or you have purposefully made it 482 to skip this.
No. That was not the issue, Lordship.
So why not by a normal revision under 397?
Revision will not lie, Lordship. Will satisfy a court. Revision will not lie because this.
But then you are coming against the order passed by appellate court. Why revision will not lie? Until and unless there is a provision of further appeal, revision will lie. Why not?
No, Lordship, because
you see, if it is just for the purpose of escaping from the clutches of limitation.
No, absolutely no, Lordship. We would have done
definitely
it. We had to weigh the options whether because their Lordship would have caught me in a very bad wicket.
482 is not a substitute of 3.
Yes, we are aware of it, Lordship. We would have never taken a chance because in any case, condition and delay court will be very liberal on us. So another 1 month time.
Your finding of appeal also is questionable. The first thing. Now again under 482 becomes a second question.
No, we had to weigh the option between 482 and 397 revision. Revision power is not there, Lordship.
It's
very
397, you will come under limitation.
No.
Limitation applies to it.
Lordship, that we can always do. We could have done it. But 482, it was because the scope is much broader. And the finding of the judges was very crucial that there was the ends of justice was a very serious issue involved here.
So you want to say that there is a choice available to you to whether opt for 397 or
we didn't have a choice, Lordship. In revisional power, because the appellate court order was final and the list was finally decided, so revision will not lie, Lordship.
That will lie. Revision will not lie in interlocutory order. Final order revision will lie. Why not?
We had to weigh, Lordship, because their technical issue would have been but if court receives the opinion, Lordship, then we'll exercise that option. But we studied that.
Not the court of the opinion. See, we have to exercise correct jurisdiction. You see, it is not something like that. You see, like the certain provisions of law has been totally ignored. Now 482 has become a very regular, like provision which has been regularly invoked for challenging any order, saying that 482 inherent unlimited power, as if unfettered jurisdiction is there available. See 397, why not your thing is there? It doesn't appear any bar.
No, Lordship is correct. But we are very limited.
What remains is that you just cannot escape from the clutches of limitation if it is an order of December.
No, our intention, Lordship, I'll be very, very candid and frank. It was never the intention to avoid a limitation. We never thought of it.
Where the vehicle is lying now?
Vehicle has been taken over by the new owner.
Then what remains there now? Huh?
Vehicle? Sorry. The instruction they haven't taken. It's still with the range officer.
Is it?
They haven't taken it. They haven't taken it.
Have you stated in your petition somewhere?
No, we haven't. With that instruction, we didn't receive.
No. Then if you
no,
what? Anyway, Mr. Khan.
Lordship.
Well,
Lordship, can I just rely on a judgment just to satisfy a court before?
On what question? 482?
No, not 482, Lordship. The query that they failed for the vote, whether at the stage of Zimma. Because I have to, even if it is on 397, if I come again on 397, I have to satisfy the court on that issue. So the texture law is immaterial so far this case is concerned.
There is not by Supreme Court judgment.
No, Lordship, very difficult.
Hindi or what? Achha, there are certain parts in Hindi.
Lordship. There's a short judgment, Lordship. Can I just read it, Lordship, please? On the bottom. Very hardly.
You can read if you desire to read, you read.
Lordship, yes. The revision filed by the state agree by the order of Session Judge so and so dated so and so, directing the release of
See,
G.
they are also revision.
No, Lordship is
Come
correct.
by way of revision. No, that
Lordship
is
is
what.
correct. Lordship is correct. Directing the release of Jeep to the respondent on furnishing security. Shri R.K. Khare, Learned Senior Government Advocate, submitted that the order of Learned Session Judge Bhopal is illegal by virtue of amendment brought out of Section 30 of the Wildlife Protection Act, which has come into effect from 2/9/1991. The amendment lays down that any vehicle has been used for committing an offence and has been seized under the provision of the Act shall be the property of government. This amendment referred to above clearly lays down that the vehicle that has been used for committing an offence has been seized under the provision of the Act shall be the property of government. This amendment refers to above clearly lays down that the vehicle which is involved in the offence and has been seized under the provision of the Act shall be the property of the
Same
state
thing has
government.
been said repeatedly.
Yes, yes. As a consequence of the amending of so and so and so and so, the original Act has been amended, taking away the power to return the vehicle. This is important, Lordship. Prior to amendment, there was a power to return to the vehicle which has been involved in the offence and seized by the official. By virtue of amending Act, subsection 2 of 50 has been omitted. Prior to amendment, under 52, vehicle could be returned, but after that, no. Now the argument, Your Lordship. The learned counsel for the respondent, relying on the decision of division bench, argued that the power under section 39 of 50 can be exercised only when an order of confiscation is passed while convicting, the question that the Lordship raised, convicting the respondent but not otherwise. Now, what is the reasoning, Your Lordship? The learned judges of the division bench in the aforesaid matter dealt with the provision of Indian Forest Act but not under Wildlife Protection Act. So, in Indian Forest Act, only after conviction, there is a distinction between Forest Act and Wildlife Act. The very purpose of carrying out the amendment making the seized vehicle as a property of government would be defeated by directing returning of the vehicle on the furnishing security to the accused. The power of
directing return of vehicle and release on Jimma are different things.
Lordship, yes.
Here return is not coming. Here it is Jimma.
Lordship is correct.
Jimma is always conditional. You are given temporary custody. It is not returned. So this judgment will not be applicable.
No, Lordship, there was an interpretation between, prior to that, there was a power for returning under section 52. Under the Indian Forest Act, the provision for, before convicting also you can return it. If you say before convicting you can return it, it's got parameter with Jimma.
Return has not coming here. It is released on Jimma.
Lordship,
please appreciate that part.
Lordship, what we can call Zimma under the CRPC, yet would be returned. The nomenclature would be immaterial, Lordship. The substance would be whether before convicting. What would we call Zimma in the CRPC would be before convicting. What would be return the vehicle would be under the.
If section 39 is accepted the way you are saying.
No, Lordship, it's not my submission, is the reasoning.
If we are interpreting this provision of law, then it will give a license to the authority to take over many vehicles, and they will do it. They will seize the vehicle and claim it to be a vehicle of the government.
But Lordship is very correct.
It cannot be. You see, it cannot. A law cannot be set in that way. Maybe we are not.
Then Lordship will have to issue notice. No. Then we'll have to strike down section 30 or read down.
That is a different issue. Whether it should be read down and whether it should be correctly interpreted, that is the question.
Okay. But interpreted would be again legislating by judiciary.
Becoming owners. Okay. Now the becoming owner is something is a transfer of ownership.
Correct.
See. So that is what is to be seen.
But then Lordship will have a very difficult situation. We'll have to interpret what is the meaning of Zimma in CRPC and what is the meaning of return before conviction in Wildlife Protection Act 1970.
Definitely, that we can
both
do.
Will be parametric.
Definitely, that we will do it. And perhaps there appears to be not much confusion. Return is something unconditional. Zimma is never unconditional. So anyway, this distinction can be done.
Okay,
you may get the difference of those sentences in many legal dictionaries also. It may not be problem. Please complete your reading.
The very purpose of carrying out the amendment making the seized vehicle as a property of government would be defeated by directing return of the vehicle on furnishing security to the accused. The power of releasing the vehicle has been expressly removed by omitting subsection 2 of 50 to ensure that the vehicle which has been seized should not be returned to the accused, in contrast with the provisions of Wildlife Protection Act.
Again, here also the accused. It can be returned to accused. If you go by this judgment, it appears that there is a bar to return it to the accused.
Lordship.
If you want us to follow the proposition laid down here. So the order impugned has not returned it to the accused.
But then if you have to
That view of the
interpret,
matter also,
Lordship,
this
if you interpret
judgment is
39, every vehicle seized in committing a crime shall be government property.
Perhaps
It
this
committing the
judgment has not taken into consideration the entire aspect.
Lordship, yes, Lordship, yes.
The provision of return to anyone and provision to return to accused are two different aspects.
But then, Lordship, how do we interpret section 39, which says every vehicle? It doesn't say owner.
That is what remains to be seen.
That is where the grey area comes. That's why, Lordship, I started with every vehicle guilty of committing an offence. It does not say every vehicle.
Let us see the language of section.
Yes, 39(2), Lordship. Lordship, before that, can we just conclude the paragraph?
Yes, why not?
Lordship, please, this judgment paragraph.
Please go ahead.
The only power reserved under the Forest Act is to confiscate the vehicle. As submitted by the learned counsel for respondent, the question of confiscation arises only after trial. The provision of Wildlife Act being different from the provision of Indian Forest Act, the observation of learned judges of the division bench will not have application to the facts of the cases. The revision is accordingly allowed, and the learned district judge Bhopal is directed to take steps to cause the jeep to be returned by the respondent and deliver the same to the Additional Inspector General of Wildlife Bhopal. So the conclusion was this: because there is a distinction between. No, Lordship will come to.
This judgment will not bind this court.
No, Lordship is not binding because this was the only judgment we found on this particular issue. Lordship will come to section 39, Lordship.
Yes.
Lordship is good. Wild animals accepted to be government property.
Yes. Yes. Please read it.
Every vehicle, vessel, weapon, trap or tool that has been used for committing an offence and has been seized under the provision of the Act shall be the property.
What do you mean by use for vehicle? Use for committing. When do we determine a vehicle has been used? When we can say the vehicle has been used? Can it be at the initial stage, at the stage of seizure?
Lordship, I'll fortify my argument.
This is what you require to appreciate this provision word by word. You can come to a conclusion that a vehicle has been used only after holding.
Lordship, allow me to reply on that. By reason of the trial court in the appellate court's order, it's an admitted fact. If they dispute that this vehicle was not used, then they have a different case altogether. They admitted.
Not coming to all those things. The question of if it comes as a criminal case, there is no question of themselves denying anything at this.
No, but it's an admitted fact. They are not decided.
That is not the things. What is your prayer at this stage? At the best, notice can be issued. Nothing.
Absolutely, because we have laid.
Not at all. Let us see what the.
No. We are not into any stage.
It will not be proper.
Your Lordship, we don't want any order from this court at this stage because it will not be proper.
Otherwise, you will say court has received.
No, Lordship, absolutely, it's only for notice.
Normally concurrent finding, and if you see the order past this, it was recorded by the court granting Jimma at the initial stage that there was no objection from.
Lordship, concession
So that is good enough.
No, Lordship, but concession by PP in the trial court cannot overcome the law, Lordship.
Since
the court itself says, no, I don't agree with this reasoning of law.
Since we have given,
I have never come across this case, Lordship. What I am saying is that what I am saying, this Lordship, is a very peculiar law.
We will just issue notice.
Yes, at this stage, yes, Lordship.
That also very reluctantly. You want it to be retained by the court?
No, Lordship, please, Lordship, don't give it. We are grateful, Lordship. Lordship is disagree with something.
But the issue is interesting.
Yes.
Sometimes the use of words in a
legislatures use the word Zimma. Lordship, we have to go to the meaning of Zimma.
Then, you see, like it's a basic understanding. You see, just because you are caught, you see, that would basically conclude everything.
Lordship, for a moment when I read this provision, that I found it very offensive. In terms of, we know what is Zimma, but I found it very offensive. Shall belong to the property of government. But then I said, like,
it is not the way actually we are looking at it. There must be something. We'll just see. We'll find it out.
But then it needs interpretation, or it needs to be read down. There has to be parametry between Zimma
Now
and
we will
return.
have more time to conduct a research on this and come out.
Indian Lordship, yes. Depends upon what the other side argues.
The only thing is that this court hopes that you will place correct proposition.
Lordship, yes. I'm grateful, Lordship, but I think so. I've assisted
Being
the
senior
courts too.
PP, it is not your duty to, you see, like.
Lordship, yes. Lordship, yes, absolutely. So we need interpretation of Zimma and return.
Yes. Right. Mr. Khan done it. Special PP.
And Your Lordship, other larger issue would be when there is a clear bar under 37, whether Zimma itself will be maintainable.
Assisted by Mr. Ekarwan, learned additional synergy. Issue notice, returnable in 3 weeks.
How Lordship?
How many respondents are there?
Just one.
Petitioner to take steps for service of notice within 2 days.
Either way, Lordship decides either way, we have got no problem. But then the issue of law is there.
That is, you see, either way means like you have to come across those hurdles. Maintainability of 480.
Yes.
Concurrent finding.
Yes.
Your submission that no objection. There are many things against.
Many things are there. Lordship is correct. We know we have to overcome that. But then the only thing is that.
In addition to what? Interpretation of the 39 which you have raised, section 39.
And larger issue Lordship will have to also address is whether in the Wildlife Protection Act, whether Zimma application will be maintainable under CRPC.
We'll just see.
When a statute clearly bars it.
We'll just see. But then you have never raised that thing before the trial.
Issue of law.
Can be. But then there are certain stages.
Constitutional court or also this court can issues.
Unlike section 24 of the CPC,
yes,
there may be certain stages.
No, Lordship is correct. That we have been, as I said. Lordship will try to assist the court. Absolutely.
Item number 2.
List of items. The last one. Yes, Mr. Nath.
My lord, this is an appeal against the judgment order convicting 7 years under section 395 and 397. Your lordship earlier dated by order dated 6 of this month. This
yes, appeal was admitted, isn't it?
Appeal was admitted.
Records
has come. So you have to prepare paperwork.
Paperwork, my lord.
Yes. Office note indicates that LC record has been received. The appellant to prepare the paperwork. How long will it take, Mr.?
2 weeks.
In the matter. Within 2 weeks.
Oh my lord, 4 weeks, my lord.
That is what you see. Like,
Normally
so you say 2 weeks. We thought that you have some urgency. So
No.
it is up to you. If you can make it in 1 week, also we'll pass that one.
My lord, 4 weeks.
What you say? Appellant to prepare paperwork within 4 weeks. Within 4 weeks. 4 weeks. List thereafter. After list.
Highly obliged.
Item number 3.
Appellant to prepare.
daily costless. Item number 1.
I'm entering appearance today, Your Lordship.
On behalf of?
For the respondent, Lordship.
Okay, Mr. There is sole respondent. Only one respondent.
Sole respondent, Lordship, yes.
Mr. Sir, give your name, please. This court is very poor in remembering name, so you have to probably tell us. Except for fellow old colleagues. Mr. Swainsa enters appears on behalf of the sole respondent today. What is your prayer then?
Lordship, may be allowed to file my counter affidavit.
You'll file an affidavit objection?
Yes, Your Lordship.
Mr. Swainsa enters appears on behalf of today and submits that the respondent would like to file an objection against objection in the matter. He prays for grant of 2 weeks.
3 weeks, Lordship.
It'll be 2 weeks, Your Lordship.
2 weeks should be enough. We'll see if you can fit. You prays for grant of 2 weeks time. Prayer allowed. List after 2 weeks.
All right, Lordship.
Hearing item number 4.
Yes, where is Mr. Devnath? Yes. You need some more time. None appears for the petitioner. Nobody is there for the petitioner.
Yes, yes.
None appears for the petitioner. Mr. R. Devnath, London CGC appears with the respondent 6 further more time for filing an affidavit in compliance with order dated 14/4/2024 of this court. Prayer allowed. List after 2 weeks.
Item number 7.
Yes.
Praying for some time, Madam.
2019 matter. Any interim order?
Yes, interim order stays there.
One interim order is there, Madam.
We will not press it for vacating.
In fact, the case can be dismissed also, Your Lordship, but since my colleague is telling me that he lost the file something.
Otherwise, it's a fit case for dismissal.
Yes, it's a good case.
Allowed
because the petitioner has not stayed in as a lessee also.
It seems with regard to lease.
My lord, the
expiry of lease has expired.
My lord, his father, the shop was under the name of his father. Thereafter, lease expired, my lord. And he has also approached the authorities, my lord, to transfer the lease and renew the lease in his name. He's been running a shop.
Can it be done in a writ petition? It should have.
Other remains. In fact, other they have gone to the civil court.
My lord,
until and unless there is a, like a violation of law.
My lord, because he was, my lord, there was a direction for him to vacate, my lord. So, and my lord, there was a certain urgency, so we had to approach this on.
Urgency will not confer jurisdiction in court, you see. Anyway.
No more time, I think.
You are ready to accommodate him.
Because he lost his file.
When do you want?
Not after 2 weeks.
Mr. K.P. Patricia, Learned Counsel for the petitioner. 6 grant of further 2 weeks time.
There's alternative remedies there.
That will record when you argue the matters. But then alternative remedies, anyway, we'll just see it. Mr. SP Montal, London Senior Counsel appearing for the respondent. There's no objection. Prayer allowed. List after 2 weeks. Make sure it finish. These are old cases. This court is not very inclined, you see. And the courts are badly criticized for not disposing these cases for no reasons. I have seen there are certain matters for no reasons it is pending for 7-8 years.
My lord, there is another aspect, my lord. This was recently informed by my client also, my lord, that there is a possibility that, my lord, the administration will be taken over by the municipal. So if that is so, my lord, I'll stand a better chance. I may stand a better
But then
chance.
that cannot be a basis for this court to adjourn the matter. You see.
That is pending for quite long before it.
There's certain other matters also, I think,
Yes,
with
my lord.
building permission.
Yes.
Anyway, we'll just see.
Much
Alright.
good.
Mr. Mohanta is appearing alone without anybody.
No, she is there. Deepala. I'm sorry.
She was not visible actually.
Yes. No,
Yes.
wanted to give her.
Yes.
Deeply always.
Item number 10.
May please, Lordship.
Yes.
This is application under 482, my lord. In the last occasion, we have filed the additional affidavit. During the pendency of this case, charge sheet had been filed. So we have brought on record those charge sheet, my lord, as an additional affidavit. However, I've been informed today, my lord, somehow response number 7 was left out to serve with the copy of the additional affidavit, which I'll provide it today, my lord.
Yes.
So, my lord.
What is then ultimately what do you want today? You want to proceed with the hearing or?
He wants some time because.
Some time, Your Lordship, for going through the documents.
You have received the only copy of the additional affidavit only today.
I'll give it today, my lord.
So you have not supplied.
But somehow, during inadvertence, he was left out, my lord.
That is all right. That is all right. Means you will be supplying him today.
Yes, my lord.
And you want this matter to be listed thereafter, is it?
2 weeks, Your Lordship.
My today date may be fixed. What happened? He's already been charge sheeted, my lord, and
that is all right, but then you verify, you check it
Now,
online,
into
you see.
all the cases are
The
seated,
problem
my
is that,
friend
Mr.
can.
You see, if we accommodate one council, then we have to accommodate many.
My lord,
that
2
becomes
weeks,
difficult.
1 week.
No, we'll give you a tentative time, but then we'll not fix a.
My lord, 2 weeks, my lord, will be.
2 weeks will be all right for you. Yes, all right. Okay, Mr.
M. Smith
submits that an additional affidavit bringing into records the copy of the charge sheet filed.
This one. Common charge sheet is there, sir. And some orders.
Filed in. What is this?
Additional affidavit.
In Thurapia's case number 99-07-2020 has been brought into record of this court. So this Thurapia's 99-07-2020 has been charged.
This is the PS case number 99.
That is all right.
No.
Just to indicate, there is no problem.
Malak.
Subsequently, they will give GR number and all.
GR number has already
That
been
is all right. That is all right. We just to give this.
Malak.
Okay. Mr. Thanks, Honorable Counsel, for the respondent number 7 submits that he has not been supplied with a copy of the additional affidavit. The petitioner undertakes to supply a copy of the additional affidavit to the respondent number 7 during the course of the day. Yes,
But at the most Monday, if at all today, we'll provide it.
Just a petitioner shall, without, do not say petitioner undertakes, just a petitioner shall supply a copy of the additional affidavit to the respondent number 7. Then give a full stop. Just on the prayers made by the parties, list this matter after 2 weeks.
Item number 12.